So today in this video we are going to discuss what is evidence and stage of evidence in a trial. Hello, I welcome you to Everything is Logical. My name is Parmeet and let's start. What is evidence? Meaning of the evidence. So basically the word has been derived from a Latin word that is evidere, which simply mean to ascertain or discover or to prove something. So basically which we have seen in the trial also, that whenever you have to prove something we have to give some evidence. Section 3 of Indian Evidence Act also defines what is evidence. So it has been defined in two clauses, sub-clauses. The first is all statements which the court permits or requires to be made before it by witness in relation to matters of fact under inquiry. Such statements are called evidence. Basically, if we try to understand this, so this is nothing but a testimony. We must have seen in the movies also that there are many witnesses which give their testimony in the court to prove something, right? To prove a fact. So in this, there is simply one thing that is very important. If we see that court permits or requires. So if a court permits or requires, then only a witness can be allowed to make a testimony in a court, otherwise it cannot. And the other clause which simply is documentary evidences, right? So it includes all documents including electronic records produced for the inspection of the court. So in this they have added also electronic records. You must be thinking what is electronic records. It is basically the evidences or something which is contained in a pen drive, or like evidences such as CCTVs or recordings in cell phones. Those are electronic records and they have been included in the documentary evidences. And conventional documentary evidences, we all know that these are the affidavits or rent agreements or any documents which is written on the paper. Now let's come to understand what is the stage of evidence in a trial. So for this, evidences are being used in all the cases such as civil and criminal cases. So we will discuss in both of the scenarios. So in civil cases and criminal cases, in civil, the first stage is that filing of a suit by the plaintiff. So plaintiff files a suit in a court, and summons are issued to the defendants, right? And in criminal cases, prosecutor starts the prosecution, or if the case is of complainant, then the court gives the summon to the warrant, or summon or warrant to the accused, right? And after that, in civil cases we have framing of issues. After hearing the charges, the court frames the issues, and in criminal cases it is framing of charges. Both are same, but the words have been different here. Okay, and the third stage, which is important for us, that is trial starts and evidence is given by the parties. In the criminal cases also, trial starts and evidences are given by the parties. So in this stage, after framing of issues or charges, the evidences are been given by the parties. And after on the basis of evidence, the court decides its judgment and gives its judgment. So that is the meaning of evidence and the stage of evidence. Thank you for watching the video, and if you like the video, please subscribe the channel and like the video. Thank you so much.